Hi, everyone. My name is Rob Verchik from Loyola University, New Orleans College of Law, and I'm moderating this roundtable discussion today called We Are All Climate Change Lawyers Now. This session, of course, is about climate change, which constitutes one of the preeminent threats of our time. During this roundtable discussion, panelists are going to explore the ways in which international climate change law is interacting with other areas of international law. That raises some potential challenges. It also creates some opportunities. And we're going to be talking about those challenges and opportunities in discrete areas of international law, as well as for the larger functioning of the entire international legal system and global relationships that are affected by that. What I'm going to do is introduce to you your speakers today in our discussion in the order in which they'll appear. So I'll introduce everybody, and then I'll turn it over, and they'll each speak for roughly 5 to 7 minutes, and then we'll have time for some back and forth after that. Our first speaker is Herman Ott. He leads Climate Earth's operations in Germany today. He's also a professor at the University of Sustainability, or rather the University of Sustainable Development at Eberswald in Germany. Herman Ott has written books and articles in German and English, scientific journals, newspapers, weblogs, all sorts of things about climate change and the environment, and particularly about the governance of sustainability. After that, we're going to hear from Carmen Gonzalez. She is the Morris Liebman Professor of Law at Loyola University Chicago School of Law. She's an expert in international environmental law, human rights, and the environment, environmental justice, and also food security. Professor Gonzalez is also a member scholar of the Center for Progressive Reform. Margaret Young will be our speaker after that. She's a professor at Melbourne Law School who specializes in public international law, the law of the sea, international trade law. She's currently leading an Australian Research Council funded project on the potential and limits of international adjudication. And she was elected just this year in 2021 as a fellow of the Australian Academy of Law. And also she works with the World Bank's Blue Economy program. Our speaker after that will be Nilofer Oral, who is a member of the United Nations International Law Commission. And she's also now the director of international law at the National University of Singapore. She has been a visiting scholar in the United States at various universities, also Cal Berkeley and University of Virginia, and her specialties are the marine environment and oceans policy. And then our final speaker today will be Sailesh Mehta, who practices law at Red Lion Chambers in London. He defends and prosecutes many types of high-profile, complex, and law-defining cases. These are cases that have to do with serious crimes, terrorism, large-scale fraud, and regulatory disputes that involve health, safety, and the environment. He lectures judges and lawyers widely internationally on environmental issues and safety issues, and he writes for the national and legal media. Mr. Mehta also sits as a recorder of the Crown Court. And so with that, we just have a wonderful group of discussants today, and I'm looking forward to moving ahead. So I'll turn it over to you, Professor Ott, to start us off today.
Thank you, Rob, and congratulations to the organizers for this timely event. Your proposition is correct. The climate crisis, or more correct, the global ecological crisis, must be the starting point of analysis and strategy for all areas of the law, and particularly international law. Because the changes brought about and the measures required to fight this crisis will radically alter the geopolitical landscape and decisively affect every branch of international law and relations. This is why every lawyer will in the future be automatically a climate lawyer, whether they want it or not, as the title of this panel indicates. But let us not be misled into some kind of complacency. In the years to come, tackling the climate crisis will require us to work hard. This is a vast topic, and I would like to concentrate on 3 points. First, climate and environment lawyers have to become more strategic in their approach. It is, of course, important to conceive, employ, and enforce legal norms. This is our core business. But we must go further. We must develop the legal strategies and institutions that will support societies and governments to effectively deal with these crises. It is important to remember that institutions should be more intelligent than the people working in them. This holds true for nation states and their constitutions, as well as for international organizations or treaty regimes. We must find the means that enable governments to deal more effectively with global problems, must develop procedures that foster decision-making under uncertainty and under competing interests. There is one outstanding example, the Vienna Convention and Montreal Protocol on the protection of the ozone layer. This treaty regime combined the experience of diplomacy through many decades of international environmental lawmaking, and thus enabled the international community to win the fight against a thinning ozone layer. The recipe for success was a combination of advanced lawmaking, effective implementation, support for poorer countries by way of a novel multilateral fund, and a non-compliance procedure that actually had teeth because it contained trade sanctions as ultimate means. All elements were important, but I would like to highlight one: decision-making by majority voting. As all our experience shows, complex problems cannot be solved if every state has to agree to everything. As soon as vital economic or strategic interests are at stake, the self-perceived national interest will most likely prevail. I know that this is a very delicate issue, especially for strong powers. But there's no way we, as humankind, can tackle our crises successfully without effective decision-making. Second, international climate lawyers must ask themselves whether our global legal institutions are up to the task. Why has there never been a real climate or environmental case before an international court? International environmental law looks back to a history of more than 100 years. There are established norms governing polluting activities originating in one country with impacts on another. Why then do we not see any litigation? This is even more surprising when we consider that the climate crisis will have, and already has, profound impacts on the human rights of every person on this planet. And that the rising sea levels will lead to a deterritorialization of some states, the disappearance of some states. Since they are only a couple of meters above sea level, they will effectively vanish. This equals the destruction of states, member states of the United Nations, without a war. And international law should have nothing to say to this threat to sovereignty. Do we need an international court on the environment? Or will it suffice to make access to the ICJ, the International Court of Justice, easier? Can amending the statute of the International Criminal Court help out of this deadlock by introducing an ecocide as a crime against the environment? This must be discussed, and it must be acted. Third point. We must realize that every lawyer can and should be a climate lawyer. The imminent danger to humankind and its civilization will require all hands on deck. We will not succeed if the awareness of the ecological crisis remains in the bubble of environment lawyers or diplomats. As Mary Hagler put it, we can't tackle climate change without you. This means that we have to support lawyers from all walks of the profession to contribute their part, be it from corporate, banking, or family law. At the international level, trade and international economic lawyers, human rights lawyers, and those working on war and peace can make a contribution. Every lawyer can and should play a role. We must ask ourselves how to educate our colleagues and indicate how they can contribute to making the world a safer place. Client Earth, the organization I work with, successfully employs lawyers from all branches of our profession. And together, they constitute a formidable knowledge pool to tackle environmental problems. We provide legal support to non-governmental organizations, environmental or not, and to governments in Europe, Africa, or Asia. We are proud, for example, that we have been asked by the Supreme Court of China to advise on matters of environmental law, and that we were involved in the training of environmental prosecutors and judges. We're also educating the private bar, explaining climate risks to them so they can warn their clients and ensure they disclose and manage their clients' risks. We see a huge role for the legal community to play in this fight. I hope that these suggestions will help to bring about a constructive and fruitful discussion. Thank you.
Thanks so much, Professor Ott. I'll turn it over now to Professor Carmen Gonzalez.
Thank you so much for including me in this discussion. I'm going to be talking about the intersection of climate change, racial justice, and how the law constructs nature. And I'm going to get there through a slightly roundabout path. Climate change is already affecting the practice of law at the domestic and the international level. It affects a variety of areas, including land use, energy, real estate, insurance, migration, trade, investment, and human rights. One of the most productive divergences in recent decades is that of climate law and international human rights law. The Paris Agreement is the first environmental treaty to incorporate human rights language, albeit only in the preamble. In addition, communities are increasingly using human rights law as a tool to achieve mitigation, adaptation, and compensation for losses caused by climate change with greater or lesser success. But the climate crisis is also highlighting the limitations of both international environmental law and international human rights law. Historically, both bodies of law sought to mitigate the harshness of the global economy without questioning its fundamental premises. Human rights law, for example, protects the rights of specific individuals and communities on a case-by-case basis, but doesn't challenge the underlying paradigms of economic development that systematically produce these abuses. Similarly, international environmental law focuses on mitigating the harmful consequences of human activity through better management of pollution and waste. Both bodies of law have historically operated on the margins of the global economy without interrogating its underlying premises, including its failure to acknowledge planetary boundaries, its commitment to unbridled economic growth, and its treatment of nature and the majority of the world's people as exploitable and expendable. As Anthony Angie and other TWAIL-affiliated scholars have pointed out, international law originates in the colonial encounter as a series of doctrines that permitted Europeans to exploit the land, labor, and resources of the Americas, Africa, and Asia. Today, when international trade and investment law conflicts with human rights law or environmental law, economic law generally prevails. It prevails because of its enforcement tools, such as investor-state dispute resolution and the WTO dispute resolution system that impose economic penalties. But it also prevails because we have so deeply internalized the duty of states and private actors to recklessly exploit humans and nature in the name of development that this is baked into our legal frameworks, even outside of economic law. The Sustainable Development Goals, for example, fail to resolve the contradiction between growth and sustainability. They call for a physical impossibility, unlimited economic growth on a finite planet. The Paris Agreement incorporates market mechanisms such as REDD+ and carbon trading, and thereby seeks to resolve the problems of climate change with the very tools that created the problem in the first place. As the climate crisis intensifies, we are called upon to rethink our relationship with nature and with each other. But crisis begets opportunity. In the time I have left, I want to talk about The impact of the growing demand for racial justice all over the world in the aftermath of the murder of George Floyd in the United States, how this relates to climate change, and what potential it holds for international law. Racism is embedded in the fossil fuel economy. The colonization of the Americas and the transatlantic slave trade provided the capital that financed into European industrialization, the cotton for the textile industry, and the commodities that enriched slaveholders, slave traders, and those who invested in this enterprise. The slow violence of the fossil fuel industry has a disproportionate impact on racialized and poor communities all over the world, from the Niger Delta to Cancer Alley in the United States. Fossil fuels are concentrated in certain areas of the world, such as the Middle East, that have been targeted over and over for invasion, exploitation, and domination. And when Muslim and Arab populations seek refuge in Europe and the United States, they're racialized. They're classified as potential terrorists and excluded. Most significantly, those most susceptible to climate-related disasters and slow onset events are overwhelmingly persons classified as non-white. They live in vulnerable geographic locations, but they have been rendered socially and economically vulnerable through colonialism and its aftermath, including military interventions, the overthrow of democratically elected governments, predatory lending, and onerous austerity measures imposed by the IMF and the World Bank. These interventions have increased poverty and deprived states of the resources needed for climate adaptation and disaster risk reduction. Racialized communities are also being displaced by measures deployed to combat climate change, including dams, wind farms, biofuel plantations, and REDD projects. Finally, racialized persons displaced by climate change, poverty, and conflict are being detained, abused, separated from their children, criminally prosecuted, deported, or simply left to drown at sea or perish in the desert when they attempt to migrate to the global north. The thread that unites these abuses is the dehumanization that accompanies racialization. Racism is an obstacle to the achievement of action on climate change. The fossil fuel industry requires sacrifice zones where the people and the land are treated as disposable and expendable. Racism makes injustice morally acceptable. Racism creates the illusion that persons classified as white are somehow immune to climate change and can remain in denial. Studies have shown that most people in the US who identify as white, if they believe in climate change, don't think that they will be affected. Racism treats as primitive and marginal the worldviews of peasants and indigenous cultures who might offer us valuable lessons on how to rethink our relationship to nature. Finally, racism creates a wedge between people whose vulnerability to climate change should serve as the basis for solidarity. Right-wing authoritarian leaders and movements all over the world are weaponizing racism in order to create cross-class alliances that prevent people from seeing the drivers of climate breakdown because they are so intent on eradicating racialized enemies, immigrants, foreigners, indigenous peoples, racial and ethnic minorities. Racialized communities are the canaries in the coal mine. They are the first to experience the ravages of climate change that all of us will soon experience. Movements for defense of livelihoods, for the rights of racialized communities, and for the protection of nature are challenging our conceptions of law and targeting powerful transnational actors. These movements are using human rights law to defend collective rights. They're engaging in law reform projects to grant legal personhood to nature. They're holding Mother Earth summits along international environmental law summits. They're participating in the creation of legal instruments that recognize the rights of indigenous peoples and peasants. They are embedding in legislation and constitutions the rights of nature and future generations and the multicultural, plurinational nature of the states in which they reside. They're occupying lands in ways that contravene domestic law, but are using the climate emergency, the idea of necessity, as justification. They're challenging traditional notions of sovereignty and territoriality as climate change threatens to render their lands permanently uninhabitable and compel migration. They are demanding accountability for the deaths of racialized people in ghettos, in reservations, in flimsy boats that try to cross the Mediterranean, in prisons and detention centers, and in never-ending resource wars. They are resisting large-scale mining, petroleum drilling, logging, and projects that treat them and their communities as waste. They are shifting public attitudes about the relationship between people and land, and challenging legal techniques that convert communal lands and resources into private property for the material benefit of local and transnational elites. Finally, they are inviting international lawyers to go beyond the silos, to go beyond their narrow area of expertise and see the ways the different bodies of law produce oppression and environmental degradation, and can be used for mobilization and empowerment. Climate change encourages international lawyers to confront the systemic injustices that have always been faced by frontline communities, and to see social movements as generators of theory, as oppositional actors that are also putting forth alternative ways of viewing the world and alternative ways of living in relation to other human beings and to nature.
Thanks very much. That was powerful. Professor Margaret Young.
Thank you. It is great to be back at the podium at an annual meeting, notwithstanding that I'm joining you remotely from Melbourne, Australia. Of course, if our work is future-oriented, problem-solving, and global in scope, we are all climate lawyers now, and well done to the organisers for stating this so clearly. But beyond the widening of the epistemic circle of climate lawyers, we must understand two things. First, that the reach of climate change law into so many other areas of international law requires an understanding of how these laws fit together, clashing, supporting, sidestepping, deferring, pulling rank. Second, that we need to constantly ask how they should fit together and for which beneficiaries. As many of you know, I have published extensively on international law's fragmentation. For the issue of climate, this leads me to three areas where trade lawyers, environmental lawyers, and human rights lawyers are all climate lawyers now, but where convergence is neither the best explanation nor the best normative guidepost. We should strategically embrace lawmaking and adjudication everywhere, but be conscious that our attention might be diverted to particular functional ends when issues of mitigation or adaptation are framed to suit the structural biases or vocabularies of particular regimes. Let me start with the trade lawyers. We have long known about the clashes when trade measures seek regulatory objectives, including environmental protection. A typical example of such a clash, met with the exception type approach, may well emerge if the European Union's border carbon adjustments, likely to be imposed on countries with weak climate laws as early as next year, are challenged at the WTO. But there is a new sensibility that places climate as a foundational regulatory objective for all trade flows, including in energy, agriculture, building, transport, and so on, rather than a peripheral exception. Current FTA negotiations from countries like the post-Brexit United Kingdom need to centre their objective of reducing the carbon footprint of their imports. We might observe that convergence is at work in President Biden's call for the elimination of fossil fuel subsidies, which currently distort market prices for oil, gas, and coal, making them cheaper than they should be. Yet, looking closer, there is perhaps something more subtle going on, especially in the interaction between regimes. Fossil fuel subsidy reform shows the importance of interaction between the trade regime and others. Just as negotiations to clarify disciplines on fisheries subsidies at the WTO have had to dwell heavily on who gets to designate subsidies as good or bad, there will be discord about which subsidies should be targeted. There is a bias, for example, towards consumption rather than production subsidies in current reform proposals, as my work on energy transitions has shown. We can also expect new rules to require the sharing of expertise, competence, and authority between international organizations, even though these organizations do not enjoy universal membership or support by states, which is similar to Herman Ott's point a little while ago. Legitimacy in regime interaction will instead flow from deliberative processes rather than direct state consent. And we must ask fundamental questions about which actors, states, international organizations, non-governmental organizations, fossil fuel companies, should be involved in establishing market conditions for energy security. It seems obvious to point out that environmental lawyers are climate lawyers, and this is my second point. But climate lawyers have long been preoccupied with demand-side policies like carbon trading, which are most often connected to the Paris goals of a 1.5 or 2 degree limit to global warming and a net zero of greenhouse gas emissions by 2050. While reducing the demand for fossil fuels is profoundly important, environmental lawyers can help focus on reducing the supply, especially in addressing the imperative to keep carbon in the ground. For example, the obligation to prevent transboundary harm has long been confirmed as customary international law, and abolitionist policies have developed to restrict the supply of hazardous wastes and pollutants. International law relating to the environment has also shaped due diligence obligations connecting states with the activities of their domiciled corporations, as was done in the pulp mills case at the International Court of Justice and the IUU advisory opinion of the International Tribunal for the Law of the Sea. So how do international environmental laws fit with the rest of public international law? Regime interaction alerts us to asymmetries in institutional power and influence, such as the lack of compulsory dispute settlement for transboundary environmental problems, as others have observed today. International courts are limited in their capacity to articulate and apply principles of responsibility. The relative weakness of international environmental law is one reason to support the Global Pact for the Environment, which has been endorsed by France and other countries as a new environmental treaty. Its proposed right of every person to live in an ecologically sound environment adequate for their health, well-being, dignity, culture, and fulfillment promises to enhance implementation and enforcement, and not just at the international level. This brings me to my third example of apparent convergence, but more than convergence, human rights lawyers as climate lawyers. Human rights claims can bring pressure on states to mitigate climate change, as Carmen Gonzalez has just described. My favourite example of this is the current complaint to the Human Rights Committee by Australian First Nations people, alleging their ICCPR rights are violated by Australia's weak climate response. Yet the disjunctures between human rights and climate law also spotlight the need for any climate mitigation to be advanced with regard to underlying inequalities and impacts. In our work on reducing emissions from deforestation and forest degradation, or REDD+, my colleagues Maureen Tian, Lee Godden, Kirsty Gover and I found that climate change mitigation has disparate impacts on Indigenous and forest communities. REDD+ policies promoting carbon sequestration risk displacing the very people who have made the least contribution to the problem of climate change. We show how the risk differs depending on the local context of REDD+ implementation, the quality of free, prior and informed consent, the protection of rights, the access to benefits, and the policies of the international funding institutions. Efforts by states to draw on existing environmental and human rights regimes, including through decisions of conferences of the parties to the UNFCCC, show state consent to be less important than other factors, providing legitimacy and accountability to regime interaction. To sum up, yes, it is not enough to identify climate law from a 5-word proximity search of the acronym GHGs. Different areas of legal specialisation are involved, including but not limited to trade, environmental law, and human rights. And we need to work to understand how norms and legal orders fit together. We also need to continue to ask how these legal orders should fit together, united as we are by the global problem, but highly unequal, both within and between states, in our contributions and capacities to deal with it. Traditionally, convergence approaches have identified possible mergers of different substantive areas or different procedures within international law, charting both international domestic alignment or international. But fragmentation approaches have identified both convergences, divergences, and something more subtle, an enlargement of different aims or goals in one area or a displacement of contradictory values in another. The new approaches to climate law call for a close charting of these trends. For climate lawyers, the search for a polity and morality that can more systematically guide global relations is ongoing. Thank you.
Thank you very much. Professor Nilofer Oral, you have the floor.
Thank you so much. It really is a tremendous pleasure to be on the same panel with such brilliant colleagues, and I'm really delighted to be here, and I'm very thankful for this invitation. And I have to say that I think my topic is following up nicely on Margaret's topic, because I'm going to speak about specifically the law of the sea and climate change. And first on the challenges, and then on the question of interaction, the need of interaction between these two regimes in order to address the complex consequences of climate change on the ocean. And here, international lawyers have an important role to play. So in 1982, when the Law of the Sea Convention was adopted after some 9 years of negotiation, climate change just was not on the international agenda. That did not happen until later in the 1980s. And then climate change was addressed under the 1992 UN Framework Convention on Climate Change and subsequent implementing instruments such as the Kyoto Protocol and the Paris Agreement. It's only in the past decade or so that we are learning from science about the multiple adverse impacts of climate change on the ocean and marine environment. The first ever IPCC special report on the ocean and cryosphere was published just in 2019. For example, the term ocean acidification was coined only in 2003. So the other adverse impacts on the ocean, aside from ocean acidification, includes ocean chemistry changes, warming ocean temperatures, deoxygenation, and of course, the rapidly melting glaciers and ice sheets resulting in sea level rise. So the 1982 Law of the Sea Convention is a broad, it addresses multiple aspects of the law of the sea, and that's why it's called often the Constitution for the Oceans. But the convention did not foresee sea level rise from climate change, and it did not foresee all the other adverse impacts of climate change, as I listed already. Now, just to give some very concrete examples, sea level rise is already impacting the lives of community in small island developing states and low-lying coastal areas. One pressing issue that is being examined by the International Law Commission and the International Law Association is what is the legal status of maritime boundaries when baselines are inundated and disappear because of climate-induced sea level rise. This is not simply a technical question of redrawing and remapping, but any change to existing maritime boundaries brings potential and quite serious economic and international relations consequences. Now, the Law of the Sea Convention itself does not provide a clear answer or solution as to whether baselines must be redrawn or whether they can be made fixed. State practice is also not clear. Another challenge is how to address the multiple adverse consequences of climate change on marine ecosystems, habitats, and overall marine environment. We are already seeing the detrimental consequences on fisheries, shellfish industry, food security, and the overall health of the ocean, which science tells us is only going to worsen unless action is taken. Now, the common factor for all these adverse impacts is excessive emissions of anthropogenic carbon dioxide. The ocean has absorbed 30% of the global carbon dioxide emissions, making it the world's largest carbon dioxide sink. It has also absorbed 90% of the planet's heat in the past 50 years, but its capacity to be a sink and reservoir has been exceeded. The solution requires mitigation of carbon dioxide. However, the Law of the Sea Convention does not provide a legal framework per se for the mitigation of carbon dioxide, but Part 12 does provide an important framework of obligations under Articles 192, 194, and 197 for states to protect and preserve the marine environment in general, and to prevent, reduce, and control pollution from any and all sources, which would include carbon dioxide. But what is missing is a process for states to take the necessary collective and coordinated action for mitigation of carbon dioxide. This is where we need to look at regime interlinkage. And in this case, between the Law of the Sea Convention and the Framework Convention on Climate Change regime. So now I will focus on the Framework Convention and the Paris Agreement. The UNFCCC regime lays out the framework for states to mitigate greenhouse gas emissions, which can be done through the reduction of any of the 6 greenhouse gases. And so it's not exclusively carbon dioxide. The Paris Agreement has also set out temperature targets, which is between 2 degrees centigrade above pre-industrial levels, and ideally to limit the increase to 1.5 degrees centigrade. It has also established an obligation for states to determine at a national level the mitigation actions they will take to ultimately reach this target through the periodic submission of progressive, ambitious, nationally determined contributions, which beginning in 2023 will be collectively assessed through a global stock taking to measure progress. However, right now, there is no indicator, no process or requirement to include the ocean in the temperature target, the NDCs, or the global stock taking. When we look at the ultimate objective of the UNFCCC, it is focused on the atmosphere, the stabilization of greenhouse gas concentrations in the atmosphere. Now, the UNFCCC does make reference to the ocean, and based on the common but differentiated responsibilities, states are to promote sustainable management and conserve and enhance sinks and reservoirs, which includes the ocean. But now, in light of recent scientific information, this also needs to be re-examined. But the point I would like to make is that the Law of the Sea Convention and the UNFCCC can operate synergistically to address the serious challenge posed by climate change in relation to the ocean. The Law of the Sea Convention lays out very clear obligations for states that are of direct relevance to climate change impacts on the ocean. But it lacks a robust process to advance these obligations collectively. There is no subsidiary scientific and technical advisory body. The states party to the Law of the Sea Convention does not adopt implementing decisions such as the Conference of the Parties under the UNFCCC or the CMA under the Paris Agreement. So here is an opportunity for inter-regime cooperation and coordination, an important role for international lawyers to promote this. Now, one last point I would like to raise in relation to the role of international lawyers. It is absolutely important that for lawyers to take a multidisciplinary approach to climate change and not simply focus on single issues. And we're seeing that. We're seeing now the intersection between climate and human rights. And I've just laid out for climate and ocean. Margaret talked about climate and trade. We have an important role to formulate and make these interlinkages. There has been an incredible surge in domestic climate litigation, but these are focused on the Paris Agreement and the UNFCCC. I think it might be time to include the Law of the Sea Convention and the ocean in these cases. And I also would echo the important points made by Herman Ott on the lack of cases at the international level. And may I say, the Law of the Sea Convention provides compulsory dispute settlement, and I think lawyers need to take advantage of this. So thank you very much for the opportunity to make my presentation. Thank you.
Thanks very much. Salish Mehta, you have the floor. Thanks very much.
Thank you very much for inviting me. In the UK, as in most of Europe, climate change is an accepted scientific statement of fact. We look across to America and are slightly dismayed to discover that something in the region of 15% of the general population do not believe that climate change is a reality. And there's a reason for that, we believe. The reason is that there are vast economic interests that have colluded to try to change public opinion, and they are largely succeeding. And they are doing it in a number of ways. One aspect of that is that something like 130 congressmen and women do not believe in climate change or are skeptics. The reason I start with that point is that I'm a barrister practicing in the UK. And therefore, for me, it is crucial to understand whether the jury that I'm trying to persuade in an environmental prosecution is going to be against me or for me, whether the judge who's going to be the arbiter of important decisions of law in my trials is going to be a climate change denier, whether the judge is going to be part of what would traditionally be seen as the establishment and therefore on the side of the large corporations that are committing environmental offences. And so it is important that we understand that we have to carry the public with us and guard against the change in their opinion. Last time I gave a talk of this sort, it was to about 500 judges from 50 jurisdictions, and I was voted the most pessimistic man in the room. So for today, I'm going to try to give you 3 feel-good stories from my own practice. But just before I do, just to show you how climate change affects a wide range of law, just last week, there was a decided case in France, a run-of-the-mill immigration case, but the court refused to extradite the applicant back to his home country in Bangladesh, because the court accepted that an important factor was that this applicant would not be able to breathe, given his disabilities in his homeland. Now, that is going to happen more and more, and that's important because the courts have recognized that it is an important factor, the right to breathe, the right to have clean air. Let me just give you some very short examples of my own practice. As you've said before, I prosecute and defend in a range of criminal cases, but I tend to specialize in the prosecution of environmental offences in the criminal courts. So just last week, on Friday, I prosecuted one of Europe's largest water companies, Thames Water. The reason that is a potential feel-good story is this, that the law relating to the sentencing of companies, water companies in particular, who pollute our environment, is changing. So about 3 years ago, the same company I prosecuted, and the company received the largest known fine in criminal law, £20 million for an offence of this sort, for allowing billions of gallons of sewage to go into the River Thames and eventually into the ocean. That was almost unheard of, that level of fine. Friday's case, there was another fine, record-breaking fine, £2.3 million. It made most of the British press and some abroad. The reason that's important is that in the old days, the large corporation wouldn't even be prosecuted. The Environment Agency, who instruct me to prosecute, wouldn't have even dared to prosecute such a large body. And even if they did, there'd be a huge team of lawyers on the other side. It would be a David and Goliath battle. And unfortunately, when it comes to environmental law, David often loses. And so there's been a change, a sea change, in the way that prosecutors and prosecuting teams now approach this sort of large corporation. So that's water pollution and a small success story relating to a large polluter of the sea and our rivers. Let me give you a second example, a case that's ongoing at the moment, and so I'll need to be careful. But I've already prosecuted this large corporation in the past. It's a multi-billion-pound company. The Bâle Convention is a European convention that was promulgated sometime in the 60s because the conscience of Europe had decided that it was wrong for the developing countries to send our waste abroad. Sadly, a lot of countries, such as India and China, wanted that waste because it made money for them. The unfortunate aspect of it was that it was the local population that suffered, and hence the Bâle Convention was promulgated to stop the export of our unwanted waste. There were very few prosecutions between the 60s and now. But in the last 10 years, the small team of environmental lawyers that I had have decided that we would actually be at the cutting edge of prosecutions under the Bâle Convention. It's the trans-frontier of shipment waste regulations that we prosecute under. We've had to go back and forth to our Court of Appeal a number of times to clarify the law. We've had to take on very large corporations and large teams of lawyers on the other side. We've had to take on the hostility of judges who wonder sometimes out aloud why a particular case is in their criminal court and why it's not dealt with in the civil courts as they would expect it to. As a result of all of that, we have now managed to prosecute about 5 or 6 major corporations and curtail their activity. As a direct result of our cases, China has now tightened up its legislation so that it won't accept a majority of the household waste that some of these companies were sending, masquerading as waste paper. The latest good news is that the last case I prosecuted just over a year ago, India has also changed its reception policies, so that paper mills in India now will check correctly and properly to make sure that the waste material is paper and not plastics. Third, very quickly, short story, relates to the export of our electronic waste to Africa. In parts in Nigeria, there is one of the biggest markets in second-hand electronic waste in the world. American TVs go there by the millions and millions. European TVs and other electrical equipment go there as well. The sad thing is that youngsters, by and large, in Ghana, in Nigeria, other African countries, strip a lot of these products, and the parts that aren't useful get burnt. And so the rates of cancer in some areas shoot up as a result, just as the rates of cancer in some villages in China, where the paper mills are based, have shot up. All of that has stopped. We even had the environmental minister from Nigeria coming to the UK court, in my case, to give evidence. And he was possibly the most powerful witness that I was able to call. And again, the jury was shocked that what looked like UK PLC trading to make UK a better place and more wealthy, in fact, was causing misery abroad. And once again, we were able to carry the jury with us, and they convicted in that case. And so those are the 3 stories of hope in my own practice, all 3 in the last 2 years. And all 3 reflect certain trends, that the judges are getting better at supporting these prosecutions. So in my water prosecution last Friday, the judge actually said in open court, it is incumbent on the courts to protect the environment for future generations. That statement would have been unheard of in a UK court from a UK judge 20 years ago. So hearts and minds are changing. Juries desperately want to stop our waste going abroad and causing illnesses there. The law has been simplified and clarified, and I now lecture a European group of prosecutors because London and the UK are now at the cutting edge of these sorts of prosecutions. And David is winning against Goliath more and more as a result of all of this.
Thanks very much. Thanks, all of you. We have just a little bit of time, and so my job is to sprinkle a little spice, I guess, on this and see. But one of the things that I notice that Salish Mehta has talked about, and Carmen Gonzalez and Margaret Young, actually maybe all of you at one point has talked about the importance of inequality, whether it's cultural inequality, economic inequality as being a driver of this. And I'm wondering in a way if it's fair to say that although we are all climate lawyers today, does it also mean that we are all lawyers who must attend to inequality as well, regardless of what area we're in? And I guess I want to ask you, Salish Mehta, maybe if I can, it sounds like some of the cases that you choose to work on have these themes. Is that because you think that that's an especially salient angle to pursue? That is, do you think that the courts are actually interested in the inequality part, or is it just that that happens to come with the territory?
The history of criminal law has been a history of inequality, in my view. Whenever you're dealing with corporations, when corporations first started to enter the scene 100 years ago, most law was designed to protect the large corporation against the little man and woman on the street. And so, yes, the history of crime has been that of inequality. And of course, it follows, therefore, that the recent history of environmental law is also one of great inequality, except the inequality seems to get played out across continents as well, rather than just at the local scenario.
Professor Gonzalez, I'm interested in the role that what we might think of as human rights and anti-discrimination law might play. We've talked a little bit about how important it is to buck up the environmental side of the equation, but I think of, the conventions against discrimination against women, the conventions against racial discrimination, refugee law, which is vastly outdated. I mean, is there a role to be looking at that sort of law to help in the climate area?
I think we need to use whatever body of law can be applied to a particular context, understanding that the way that we conceive of anti-racism as anti-discrimination barely touches the surface, right? Sometimes what's going on is not discrimination, but exploitation of laborers, expropriation of the lands of peasants and indigenous peoples, even though the ideology that may be justifying it is one of dehumanization. So part of what we need to do is go back to the Durban Declaration, remember the World Conference on Racism, that talked about the need to expand how we think about racism and to consider what adequate reparation is for the harm that has been done. Very controversial, but the thing is that these harms have not stopped. They just manifest themselves in different forms. They shapeshift. And the legal tools we have now may be useful in certain contexts. They fail in others, as we have seen in the United States. So we use what we have, but we also need to be aware of how do they need to be developed and what other tools exist around them that might be used and what new bodies of law may be developed, such as conventions and declarations on the rights of indigenous peoples, on the rights of peasants.
Professor Young, I want to ask you a question about, this is a question, when I teach international subjects, my students are always asking, and I never had the right answer. I mean, they're always disappointed to learn that international law in the traditional sense is just among member states of whatever the conventions are or whatever. And you made the point that we need to start thinking about NGOs and companies and individual states and maybe individual people. How do you suspect, what is the role of civil society in the international law that you hope that we will move toward?
Thanks, Rob, for the great question. Yeah, you're right that civil society is beginning to emerge as a subject of international law, just as states are, although, of course, they lack the sovereignty and other aspects. This is particularly important in issues of fragmentation and regime interaction, because treaty regimes are created to satisfy the needs of the member states as a particularly positivist conception. And then when you have traversing of regimes, if the states are not on board with the interactions, the risk is self-contained regimes and isolation. Civil society, however, have proved to be very important in building networks, building the bridges between regimes, and this has occurred particularly, I think, in the trade space, with civil society organisations very active in Geneva, in the fisheries subsidies negotiations, for example, trying to build awareness and momentum in reaching out between the Food and Agriculture Organization, the WTO, and a whole range of other bodies. Of course, that then leads to questions for academics. Well, what is the legitimacy of civil society groups? They're not voted in the same sort of direct representation as states acting for their citizens. And I claim that actually they do have credentials. They have deliberative credentials. They advance issues and needs that are often left behind by states in their conception of national self-interest. And in the environment would be one of the key issues that I think NGOs have advanced in the past and need to continue to advance for the future. So international lawyers need to accommodate this in our theoretical conceptions of the subjects and objects of international law, and to find ways in which civil society voices continue to be heard. Rob, can I just follow up too on the inequality question, because I really liked that one.
Yes.
I think that there's a really important aspect here to youth as a member of our society that are left behind. There are vastly unequal ways in which climate change will play out. We're leaving the youth with the problem in a sense. And yet in our formal legal structures, youth do not have voting rights. They are outside of the sort of formalized role of the legislature. So this, I think, is an important aspect in domestic climate litigation, where we're seeing a lot of those youth cases, but also in our concept of education. This ties in with some of Salish's comments about the polity needing to be aware of climate, but also in legal education, we need to leave our lawyers with the skills, including through the areas of law that we've mentioned today, to start to address the issue. Thanks.
Really good point. I'm glad you made it. And of course, this relates to issues that Herman Ott brought up about litigating in international courts, who gets to be involved in that and who doesn't, and obviously issues of global commons like the high seas that Nilofer Oral has talked about. We are going to have to leave it there, but I just want to say thank you so much to everyone. This has been a delightful conversation. I want to thank the steering committee for the Society's signature topic on international law and climate change. Want to thank Cinnamon Carlarn for doing so much great work in helping to put this together. And just a reminder for those of you who are watching, the audience is invited to participate in an open Zoom room, which we are providing after the meeting as you're watching it. And you'll be able to go into that Zoom room and to chat among yourselves, discuss some of the issues we brought up. And if you're lucky, if we're lucky, even some of the presenters that you just saw today will be in that Zoom chat room too. So thanks very much.